folks, and I will get started in just a moment. Okay, well, I'm welcoming everybody. Thank you so much for being here. I'm Eileen Freed, and I'm the Executive Director of the Jewish Federation of Greater Ann Arbor. We know that there are some folks who are not yet on the call, but we hate to punish the punctual, so we're going to get started. I am always the one who goes over the technical details. So firstly, to ensure that everybody can hear and that our speakers are visible, we've muted everybody except the speakers and I guess myself. And we ask everybody on the call to please make sure you're on mute. If somebody's called in, please make sure you're muted on your phone. That often tends to be a glitch. We will have time at the end of the presentation for questions. So we'll take those questions by chat. So if you have any questions, please put them in the chat box. And you can also, one of the nice things about that, we're having the chat available to everybody. And that way you can see if somebody's already asked your question, maybe you can ask a different question. We'll collect them and then moderate the question and answer at the end. We are recording this session so that we can share it with people who weren't able to join us. So we just want to make sure that you are aware that that is happening. And finally, as we've already noticed today, today's been a day for computer glitches and internet glitches. So as with any technology, we may experience some glitches, and we really appreciate everybody's patience during this call. And so speaking of glitches, I was going to be turning the Zoom over to Susan Fisher, who's our Foundation Committee Chair. And so she is on the call, and you can feel free to chat her, but I will take over our more official introduction and welcome and let you know who our speakers are. So good afternoon and welcome to the first of what we plan to be a series of programs designed to inform local donors and philanthropists and to educate community members about planned giving, endowments, and how they can make a difference in the community through the Jewish Community Foundation. The Jewish Community Foundation Committee is working hard on behalf of our community to expand awareness around planned giving, and we're proud that Ann Arbor has been selected to participate in Life and Legacy, a project of the Harold Grinspoon Foundation. Over the past 8 years, 63 participating communities across North America have secured more than $1 billion in legacy commitments. 11 local Jewish organizations and congregations are engaged in this collective and collaborative campaign to ensure the strength of our community now and for the future. You'll be hearing a lot more about Life and Legacy in the fall, in the coming months. Our big training kickoff is September 1st, so you will be learning and a lot more about this very important and exciting program. So now I'm very honored to introduce our esteemed panel of experts, and I'm so grateful to the Jewish Federations of North America, particularly Dirk Bird, who is now not on the call because he had a conflict, for making today's program possible. Stephen Wolf is the Senior Tax Policy Counsel at JFNA, Jewish Federations of North America. In this position, Stephen advocates and lobbies before Congress and the executive branch regarding nonprofit tax issues. Prior to joining JFNA, Stephen worked in the National Tax Office at PricewaterhouseCoopers and its predecessor, and he received his undergraduate degree from Georgetown, master's from Brown, and law degree from American University. He frequently lectures at professional education programs and is a published author and editor of numerous articles and books regarding tax strategies. Paul Feinberg retired from the Cleveland office of a national law firm, Baker Hostetler, in 2006, where his law practice centered on tax-exempt organizations, nonprofit corporate law, and charitable giving. Since retirement, Paul has been serving on a volunteer basis as a member of the staff of the Jewish Federation of Cleveland, where he advises on issues related to the donor-advised funds, supporting foundations, and a whole host of other things related to planned giving. Since his retirement, Paul has also been volunteering as a legal advisor to JFNA's Planned Giving and Endowment Department. Paul has taught courses on the law of nonprofit organizations at Case Western University, and we're delighted to have him here. Alan Gross graduated from Vanderbilt University School of Law in 1974 and worked as an attorney in Cleveland before joining the Federation professionally in 1984. By the time Alan was retired from the Federation of Cleveland a couple of years ago, he was vice president, and responsibilities included endowment development and tax policy related to charitable giving and exempt organizations. For many years, Alan co-chaired the JFNA's Domestic Affairs Cabinet Charitable Giving and Incentive Workshop, and he received the James Coway Mentor of the Year honor by Northern Ohio Planned Giving Council in 2012. Alan was named Distinguished Estate Planner of the Year by Estate Planning Council of Cleveland in 2018. He is also a proud veteran, having reserved in the United States Army Reserves, retiring with the rank of Lieutenant Colonel. So I think everybody can agree that we have a highly esteemed panel, quite expert in their field, and we're so grateful to have you all here. And so now we will commence with the PowerPoint and with the presentation. I'm not sure who's speaking first.
I am, Stephen.
Okay, all right, great, excellent.
So thank you very much, Eileen, for the introductions. And it's great to be with you folks today virtually on Zoom. We've done a lot of Zoom calls and a lot of Zoom webinars in the last several weeks and months. I don't know if anybody's been on any of the Paycheck Protection Program webinars that I've done. I can't even count how many I've done over the past several months, and I hope those programs and the have been helpful to the community. And I was especially interested in your introduction about Life and Legacy. That's a wonderful program. Great to see that you guys are going to be part of that. I've been part of it myself in 2 different communities, and we've also been part of the program at JFNA, and it's so incredibly important. I think it's something that you'll get a lot of satisfaction and a lot of commitments from over the next several weeks and months. And I'm happy to be here with Paul and Alan, sort of 2 of my longtime colleagues. Alan was really instrumental in bringing me to JFNA and working with me and mentoring me when I came to JFNA so many years ago, and it's great to be with them again. So we're going to talk a little bit about legislation that's taken place, how it affects charitable giving, and how it can also affect some plan giving ideas, especially with retirement assets. And I thought I would just start by giving a little bit of a background and setting the stage for where legislation has taken place already, and where legislation is potentially going over the next several days and weeks in response to the COVID issue. So I think a lot of us are familiar with the fact that in late March, the CARES Act was passed. That was actually the second piece of COVID legislation that was passed by Congress, but it had the most important provisions impacting businesses, individuals, and organizations, including several important changes but temporary changes in charitable giving, and we'll go through those in a little bit of detail. It also made some significant changes in retirement provisions that can be of sort of positive and negative impacts potentially on what donors and what tax advisors and other planners may be talking about with retirement assets, especially IRA and individual retirement account assets. And we'll go through those in some detail. And then we'll talk a little bit about what's happening right now on Capitol Hill. As you probably have read about over the last several weeks and months, the House did pass a very, very large additional relief bill back in mid-May called the HEROES Act. It has actually $3 trillion worth of provisions in it. Not a lot that actually will impact this talk, but sets the stage for negotiations that are going on right now on Capitol Hill. Last Monday, in fact, the Senate Republicans finally unveiled their counter-proposal, if you will, called the HEALS Act, which has, again, it's a very, very large package of about $1 trillion. It does have some retirement provisions and some charitable provisions in it, although not the provisions we really are hoping for. And we will talk a little bit about where the ultimate package may come out, or at least we're hoping that it'll come out. And those last 2 points in this slide talk about the fact that there actually was a July 31st deadline, and I guess we dropped the 1 there, and an August 8th deadline. On July 31st, as we all know, the supplemental unemployment provisions expired, so that those individuals that have been receiving the $600 a week from the federal government, those payments stopped as of July 31st. On August 8th, the Paycheck Protection Program expires. So those were really 2 deadlines that we thought would be pushing Congress to act. Congress almost always takes the time to never act until they have to act, and deadlines are always important for them to push them to reach a final agreement. They missed the July 31st deadline. We don't think they're going to meet the August 8th deadline as well at the end of this week. But if there's one thing that people in Washington try to do in August, it's get out of town. So I think that Congress will try to reach some agreement. And there was a little bit of talk even last night that by next week, perhaps a week from Friday, there will be a final package. And we'll talk about how that can impact some of the things, and strategy we're talking about today as we go forward. So on the next slide, we can talk about what's in the CARES Act, how it pertains to charitable giving. There are 2 major provisions that are in the CARES Act, that are in the law for this existing tax year, the calendar year 2020, but 2020 only. There is a provision that will allow every taxpayer to claim an above-the-line charitable deduction. It's only $300, and it's $300 regardless if you file singly or if you file a joint return. But it is a recognition by Congress that charitable organizations need support, and that based on what Congress did in 2017, by greatly restricting the number of taxpayers who itemize their deductions, most taxpayers, the overwhelming majority of taxpayers, actually probably close to 90% of those that file their tax returns do not itemize anymore because of the expansion of the standard deduction and other changes in the tax law that was made in 2017. Limitations on state and local taxes of $10,000 is a great driver of that provision. So we were very pleased to see that Congress at least recognized and made at least a token effort to provide a charitable giving incentive for all taxpayers, providing a $300 deduction for 2020. Now, it's only for this year, and it's cash gifts only. But we are working very, very diligently with a lot of members on both sides of the aisle to get this provision expanded greatly for this year and extend it on into the future. We'll talk about that in more detail later on in the presentation. Perhaps what's more important for the audience today, and for for a lot of our donors and a lot of professional advisors that work with donors and plan giving advisors, such as those at the Federation and the Foundation, the current limitation on the size of the charitable contribution has been lifted for 2020. Basically, there's a limit of 60% of adjusted gross income. That's the term AGI for a charitable contribution in any year. So if you have $100,000 of adjusted gross income, you were limited to a cash contribution of $60,000. Anything above that would have to be carried over to a future year. That cap has been lifted for 2020. So for individuals who are thinking about making large charitable contributions, this would be a year to do that. Now, again, that limitation, that provision has two important limitations. One is that it is for cash gifts only. Now, many of us in this space talk about the tax planning idea of using appreciated assets, such as stock that may have increased in value, as the type of asset that you might want to use to make a charitable contribution. Unfortunately, that provision will not work in terms of this lifting of the cap. It is only for cash gifts. But for individuals who perhaps have significant assets that have been reduced to cash, including retirement assets, again, this could be an important provision that could work with some of the retirement provisions we'll talk about in a few minutes to make a large contribution in the year 2020. Now, another important restriction on this provision is that this cap lifting will not apply to gifts to donor-advised funds or supporting organizations or supporting foundations. So again, it would have to be a contribution to an operating charity. So if you've already established a donor-advised fund, and I'm hoping that virtually everybody on this call does have a donor-advised fund or is thinking about establishing a donor-advised fund, that cap lifting would not apply to those contributions, but you could make that contribution directly to the federation. And so that would be basically that third point, the opportunity to make larger than normal charitable contributions in the year 2020. There is a movement, again, to extend this provision for 2021. I think that when Congress passed the CARES Act, everybody was hoping that the pandemic, the situation we were in, would be potentially coming to some resolution, certainly by now, and there would not be a need to extend a lot of these provisions until the next tax year, the next calendar year. But I think as Congress is thinking about doing perhaps one more final piece of legislation, extending these provisions for the next tax year, 2021, is getting a lot of play. The next sub-bullet talking about combining it with reducing an IRA balance is something that I think that both Alan and Paul will talk about in a lot more detail. But again, that's a potential strategy to think about for donors and for advisors to talk about potential donors. Of course, when you talk about taxation and federal tax issues, it's always important to look at the big picture. And one of the aspects of the big picture is the state and local income tax provisions and how the state treats similar types of issues at that level. Certain states do not automatically adopt federal tax changes. I will admit, quite frankly, I'm not an expert on Michigan state taxation. Alan and Paul always remind me about the different rules that apply to Ohio. So one of the things is to look at what the state implications are in terms of making large gifts, because the benefit may not be there at the state level. And also another thought and another thing to look at is to look at the overall tax picture of families, individuals, donors, to see if there are other implications of making or not making certain donations this year. Many provisions in the tax law and in other provisions of the law, such as Social Security benefits and Medicare payments, are based on adjusted gross income. So to the extent that you can lower adjusted gross income, that could have a positive and an impact on lowering the cost of certain things like Medicare payments, as well as potentially avoiding any Social Security tax liability that might be implicated. And again, all of this really should be part of a big picture discussion with donors sitting down with their tax, financial, and charitable advisor. We're not supposed to give tax advice at JF&A, and we really advise you to think about the big picture when we talk about these issues. Moving to the next slide in the retirement provisions, that were in the CARES Act. There are three basic important changes in retirement tax law that were enacted in the CARES Act, and they all go to basically making retirement benefits, retirement assets more accessible or easier to access for retirees, and lowering the tax cost and tax penalties of making any of those or accessing those funds, if you will. The first is something that's called coronavirus related distributions. These are distributions from a retirement account, any sort of retirement account, including an IRA, where individuals who basically have been impacted negatively by the pandemic, those unfortunately who may have contracted the virus or had someone in the family who's contracted the virus, someone who has lost a job, someone who has been financially disadvantaged, either having a reduction in their hours or their employment situation. Those individuals can basically tap into their retirement accounts, and there will not be any penalty to do so. There's usually a penalty of 10% for any withdrawal from a retirement account unless you've reached the age 59 and a half. Those are waived for these so-called CRDs. Additionally, to the extent that you take a CRD up to $100,000, any tax liability that you might incur for that distribution this year would be taxed ratably over 3 years. So basically it's a sort of an income averaging idea that allows you to basically tap into those funds if you are unfortunately you need to do so, and only have to pay the tax over 3 years. So again, it's a favorable provision for those who unfortunately are in a situation where they have to basically tap into those funds. The second point is that, and by the way, the CRDs can be rolled back over into the retirement account with no penalty. So you can avoid the tax situation. So if you could take the funds out, potentially use the proceeds for a short-term expense. Again, if you've lost a job or had someone, unfortunately that has been impacted by the virus, but then you can basically roll the funds back into the plan and not have any tax liability at all. So it's a very, very favorable provision. The second is sort of the loan provision, if you will, which is sort of similar to the distribution, but with the idea that the funds will always go back to the account. This allows plans to set up loan programs and basically allow those individuals, again, in certain situations, but a broader amount of qualification to get a loan from their retirement account and then potentially pay those proceeds back over time. Finally, and probably the most important provision as it pertains to those over the age of 70.5 or 72 is that the required minimum distribution from a pension plan, which I think many of us are familiar with, those that are reaching that age or that have reached that age, the basic requirement that you have to take out and take into income a certain amount of your pension accounts, those distributions have been waived for this year, for 2020, so that there is no requirement and there is no so basically you keep the funds in the retirement account and no need to actually pay tax on the amount that would be distributed. Now, there was a little bit of confusion on how these provisions would work because there's basically, there's a 60-day window for individuals to basically return any RMDs that have already been taken this year back to their retirement account and not have any tax liability. There was a problem with basically the deadline for these provisions, which was extended by the CARES Act, but the IRS has actually extended the deadline even further. So if individuals had taken an RMD before the pandemic, really struck in March. A lot of people take a monthly distribution from their pensions when they reach the age of 70 and a half or 72, and are required to take that distribution. Those individuals can return those distributions to their accounts by August 31st, and it would be basically as if there's no harm, no foul, no need to take that into income. In addition, there is a general rule which allows a one-time rollover from a distribution from a pension plan back into the plan for individuals. And that's the rule is basically within a 12-month window, you're only allowed one tax-free rollover. These rollovers that are going to be in response to the pandemic rulings will not qualify. They won't be held against the one rollover rule. So they're non-rollover rollovers, if you will. Basically, they're forgivable redistributions back to the pension plan, as long as they're done by August 31st of this year. So that's an important point, again, for advisors to be talking to potential clients about getting those rollovers done by August 31st. Paul and Alan, before I move forward, any comments on what we covered so far?
I think we'll cover that in our discussion.
Okay. So moving to the next slide. And this is really the CARES Act requirement distributions and how they impact IRAs, how they impact qualified charitable distributions, the so-called IRA charitable distribution rules. And it's important to note that individuals who reach the age 70 and a half can make distributions from their IRAs directly to charities and qualify for the IRA charitable rollover. Now, even though there is no requirement to take a distribution this year, individuals can still make IRA charitable rollovers after they've reached age 70 and a half. And I know Alan and Paul, you both have extensive experience with the IRA charitable rollover in the Cleveland area. And we can also say that the IRA rollover has been a really proven incentive for supporters, donors to make contributions and get assets out of their retirement accounts into the hands of federations quicker and sooner. And Paul, I'll leave it to you to really go through a lot of these points and talk about what the importance of this is and the interaction between no RMD and the QCD.
Yes, thanks, Steve. I think, as you mentioned, at least in Cleveland, these QCDs have been an important part of our revenues both in the annual campaign and in certain planned giving situations. And we have a number of wealthy donors who have been making $100,000 distributions out of their IRAs to the Federation. And of course, there's this limitation where they can't make these QCDs to supporting foundations or to donor advised funds, which is a particular limitation. Mm-hmm. So this has basically been focused on either annual campaign, paying current pledges, annual campaign, building up an annual campaign account for future years, or alternatively funding some sort of a planned gift and an endowment fund or something like that. This can be an important tool. However, on the other hand, donors who are very income tax sensitive may say, well, why do I need to do this year? I'm not going to get any benefit from it because if I wait, I can get a benefit next year. And so one of the points that may concern us from a development standpoint is that donors may hold off on these QCDs for their campaign gifts or for other things. And they may say, you know what, I'm still going to be as charitable as I always was, but I'm going to give my $100,000 next year rather than this year. And then you run into this limitation if they defer their 100,000 or whatever they do, I mean, to next year, they may run into the limitation, or B, they may just decide that's enough for this year. On the other hand, people who are making less than $100,000 QCDs may decide to double up. That is, that let's say someone was normally doing, say, $25,000 a year in QCDs. So they say, okay, I'll do my 25,000 for 2020 in 2021, and I'll also do whatever I projected to do. And they may wind up giving $50,000 in QCDs in 2021. The problem, as we've seen it, is are we going to be able to deal with this deferred giving? And do we have to take it into account? So one of the questions for your federation is, how much in QCDs have you gotten? And are you going to have to plan on perhaps not getting them until 2021, until January of 2021? Because as Steve mentioned, the other aspect is that the higher standard deduction means that many people are not being able to deduct charitable contributions, and many people in this older age brackets may not have mortgages, and so the $10,000 limit on state income taxes really reduces their ability to itemize. Hopefully, they don't have medical expenses. That's not always a good deduction, and they can't. They can't get a charitable contribution deduction for what they do. So again, they may say, I'm going to wait to do all my charity in 2021 through my QCDs because I get a tax benefit and I can't get a tax benefit this year. So that's an important, thing to take into account. On the other hand, can we go to the next slide? I think that's one that's relevant. Steve didn't go into this, but there are some new rules in terms of inherited IRAs that make it slightly less or somewhat less favorable for people to give IRAs to their heirs. There's a 10-year payout rule now for inherited IRAs. And obviously, you have to understand when an heir inherits an IRA, they will pay income taxes as they take distributions out. So from a development standpoint, it seemed to us that it might be important to talk to donors about the added advantage now of using IRA assets to fund your charitable gifts, and thus leaving your non-IRA assets that don't carry any income tax burden, giving those to the heirs. So, for example, if someone has in their documents now gifts to charity, on my death, I want X to go to the Federation and Y to go here, or maybe some of them have had dollars going into their donor advised funds and then have a testamentary letter that says, at my death from my donor advised fund, make the following distributions. Discussions with them might be fruitful to say, you should really try to use your IRA assets to fund those gifts rather than making the gifts outright, out of your non-IRA assets. So it's something to consider in terms of discussing with donors in light of this new change, which make the IRAs for heirs slightly less beneficial, because before they could take them out over their lifetime, but now there's a 10-year limitation. So that also leads to the other question for certain donors who are more sensitive about their estate taxes than their income taxes. The other issue would be, well, why shouldn't they continue to make their $100,000 QCDs in 2020, even though they may not get any income tax advantage? They do get $100,000 out of their estate. And so again, this might be an opportunity to discuss with them funding that planned gift, that endowment fund, Lion of Judah, or whatever in 2020, getting $100,000 out of their taxable estate. So those are a couple of thoughts that we had as we were discussing what people should be thinking about. I think you could go to the next slide.
Paul, before we do that,
another comment.
Yeah, can I just, I sort of want to ask you a question I think maybe just to sort of broaden the discussion a little bit. You talked about the fact that for many people, the IRA charitable rollover really becomes the charitable contribution deduction because they can no longer itemize. I think we've found over the last 2 years a much broader use of the rollover for people over 70.5. Can you comment on that and really the importance of really having a sort of a robust IRA charitable rollover program in a community, and how successful it's been in Cleveland?
Well, I would comment this. I'm in that exact category myself, and I basically do all my charitable giving through my IRA. I can't itemize, and so this is my primary source. And I have a dilemma this year. That is, on one hand, as a tax lawyer, I'm very tax sensitive, and so my instinct is to defer all my giving until January 1. On the other hand, I'm also very sensitive to the needs of the organization. So it's somewhat of a dilemma for someone like me. So I don't know. And the question is, in Ann Arbor and in Cleveland, are we going to be able to weather any reduction and wait until January to get certain money from our most dedicated donors?
Yeah.
So I don't know if anything's been done, and if you want to have any discussion about that, we could. So,
Paul, I could weigh in here just for a second. From a planning perspective, given, again, this goes back to comments both you and Steve have made, given that the AGI ceiling has been lifted for an individual donor, and that IRA QCD distributions can be made this year, but are not available for distribution to donor advised funds or supporting organizations. From a planning perspective, another approach, as I think Steve mentioned, would be to make these distributions and take advantage of the fact that they can be made to endowments. Both the QCDs as well as the additional cash contributions can come out and be used to fund endowments. And one little planning idea that I've considered, and one that might be considered in other communities, there are advised funds which are not considered donor advised funds, are not falling under the sort of the statutory definition, which will qualify for both these QCD distributions as well as these cash contributions, which can be now made up to one's AGI ceiling. That's a possibility which can maximize additional contributions coming from donors, and under the right set of circumstances, is something that ought to be considered.
Comment on that. So what Alan was referring to, a donor could set up a fund at the Federation that would be limited, that the donor could continue to make advice, but the distributions would be limited to the Federation itself for the campaign or for direct projects undertaken by the Federation and so on, not to other organizations. And that might be attractive to some donors who, historically have supported Federation, quote, projects, or the supplemental campaigns or whatever it is, where the dollars are not going to other organizations, but they're going to the Federation or to the Federation for, further use. So that's the kind of what we call non-statutory DAFs, where the donor still retains some ability to make recommendations.
It's two very, very good points. And I would just point out on the slide before we move forward, there seems to be a movement in Washington to think about whether or not the RMD concept really is necessary anymore. We noted on the slide that only 20% of IRA holders take out just the minimum from their account. Most people, take out much more than their RMD because they need those assets to basically support their lifestyle, if you will, in retirement. But I think maybe for our donor base and for those that are a little bit, perhaps a little bit more well off, they really don't need the RMD. So combining, the concept of the RMD with the IRA charitable rollover, I think has been very, very beneficial to the Federation system, and something I think that, again, with the enactment of the change in the so-called stretch IRAs at the end of last year, is very, very important. The other change that was made at the end of the last year in the stretch, in the Secure Act, was the RMD age was actually boosted up to 72. It used to be 70 and a half. So again, there's this sort of a delay and a diminution in its value, if you will. And I'll just make one more comment before we move forward. We have been trying unsuccessfully for many, many years to get the IRA charitable rollover QCDs to be made, to allow them to be made to donor advised funds. We're making a lot of progress in this battle with Congress. It's really part of the battle to really educate Congress about how donor advised funds are not a tax loophole. They're not a warehousing of funds. They're not this really bad thing, but in fact are just so beneficial to society and to charities, to philanthropy. We're making a lot of headway, and one of these days we'll be able to say that you can make those contributions to IRA, to donor advised funds. We're not there yet, but we're getting closer and closer. And Alan, you might want to just kick off, or Paul, the next slide, because again, it's sort of talking about some recommendations.
Well, obviously, we thought that this was a good time to review charitable giving. And we also understand that, I understand that in light of the pandemic, that a lot of people are doing a lot of work on their estate plan documents. As a matter of fact, Alan's wife is a estate planning attorney, and she's been very busy with her clients coming out of the woodwork, right? Wanting changes made right away.
It's true, Paul. Many have come out after 10 years of silence, all of a sudden.
So this may be a good opportunity to open those discussions, because people are working on their estate planning documents, and in other years they might be reluctant to go to their lawyers to make changes and so on. So this may be an important time. And then I made the point before that there may be some cash flow implications from this. And I think the third major takeaway is that, the use of, we didn't talk about this. If someone really wants to take advantage of the unlimited charitable deduction and they want to unlock dollars in their IRAs, particularly those who have IRAs that are just, they're not important to their lifestyle and so on, and they want to, want to give more non-taxable assets to their heirs, I mean, you could take the dollars out and get 100%, AGI deduction by taking the dollars out and giving the money away, so there'd be no tax cost. But unfortunately, here in this area, the state tax implications may be important. So in Ohio, if someone were to do that, they'd have to pay Ohio income tax because there's no Ohio deduction. And as I understand it, and I was looking at it this morning, I understand that Michigan is like Ohio with no charitable contribution deduction or charitable credits. There were some, and they were done away with. So if someone wanted to do this, take a large amount of money and contribute it, say to get it into their DAF as a cash contribution, they'd have to deal with paying a toll, which would be the Michigan tax. So that is a thought. Some sophisticated people might say, well, that's fine. I'm happy to do that. I want to get more money into my donor advised fund, and this is the way to do it. Alan, any other thoughts?
Paul, I think this is more of a practice point. I think as much as we treat the QCD IRA discussions as second nature, it's up to us, and I'm speaking more from my experience on the endowment side, getting this information out to both donors and advisors on a regular basis, and in particular to the advisor, because I think there's a multiplier opportunity getting this information out to advisors on a frequent basis. Having these kinds of discussions, I think, is truly invaluable, because advisors typically work with many potential contributors who will benefit from this kind of discussion.
Yeah,
I see that there is a question that we might want to address, and any other questions that we might address. So, Steve, you want to take this first one that says the new rules on the stretch IRAs, the 10-year payout.
Mhm.
I think that only applies to newly inherited IRAs, not existing inherited IRAs.
correct. Basically, the old inherited IRA before the effective date of the tax law change at the end of the year would be grandfathered under the old rules. So yeah, we're talking about new distributions for those who pass away and don't provide the IRA to their spouse. There's an exception for the IRA passing to the spouse, but to other individuals and children, basically the rules would apply, and that 10-year rule would apply. So that's in fact absolutely correct.
And
And
I
then
think,
there's
go ahead.
then there was a second question about, can the inherited IRA, this is under a newly inherited IRA, in total be used to fund an endowment or only the RMD? And I think the answer to that is you can take as much as you want out of an IRA. So you can take more than your RMD if you wanted to.
Oh, absolutely.
And again, theoretically, subject to the state tax implications, you could take the money out and put it into make a cash contribution and use the unlimited, the new unlimited AGI rule at this point. But there's another interesting thing about inherited IRAs. You don't have to take a distribution until year 10. You can leave it in there, but the price you pay is you'd have all accumulated income and plus the principal itself, you'd have to pay income tax on.
And I suppose if you were inheriting an IRA and you were over the age 7.5, which I guess could happen potentially from, maybe a brother or sister, you could also use those proceeds to fund a QCD up to $100,000. So yeah.
Yeah, you can't use a QCD out of an inherited IRA unless you are on the appropriate age, which is 70 and a half.
You have to be 7.5, to do that. Yeah. Yeah, and I think there was also a question about defining what a supporting organization is. And that's a supporting organization, or referred sometimes in our world as supporting foundations. That's a separate taxable entity which qualifies as a public charity because it supports another public charity. So, and that's a vehicle used typically by an individual or family with quite a lot of assets to set up a organization which supports something like the Federation and to avoid private foundation status. Not all that common in our world, although to the extent that we have supporting organizations, supporting foundations, they are very, very large entities and very, very important in terms of their support to Jewish organizations. I'm not sure that there are any in Ann Arbor, but Alan,
we have over 50 in Cleveland, and
yeah.
and usually a balance of about $1 million, and we have 3 or 4 that are in the large.
Yeah.
And families have decided to use this approach because they essentially want to involve their next generation. They want a clearly identified entity. They want to be able to send out checks on their own schedule. They may want to do their own explorations about who to give money to, and so on. But they've been a very important tool in Cleveland, and also they, as you might expect, they do provide some very, very significant support to our annual campaign.
Paul, I would say from a practice standpoint, our experience in Cleveland goes back many, many years. And over the years, we have found that donors who choose the supporting foundation, supporting organization platform are considered not only very generous, but also considered mature donors. They've been very involved with Federation over the years. They know the landscape, and they have considerable trust in Federation as a ongoing platform, not only to work with them, but their children and potentially their grandchildren as well. So it's not something that a donor might come to just coming in off the street. It's something that happens over
and
time.
One technical point, in order to qualify as a supporting organization or supporting foundation, the model in Cleveland that we use, it's called a Type 1, and it means that the donor and the donor's family have to give formal control over the entity to the Federation. So the typical board is 4 Federation appointed or elected trustees and 3 appointed or elected family trustees. So it's sort of like the donor advised fund in the sense that a donor has confidence that if they put their money in a donor advised fund, that their recommendations are going to be followed. But as a legal matter, in the donor advised fund, the Federation owns the property, and in the supporting foundation world, the Federation has formal legal control over the entity. But obviously, they work with the family to carry out the family's charitable objectives.
Before we answer a couple more questions, I just want to make one pitch. It's on the last slide, which I think you took down, but that's okay. I was just going to make an update on what's happening right now in Congress. And eventually, the Senate and the House are going to get together, the administration are going to get together and pass something. And whether or not it's called CARES 2.0 or HEALS or HEROES or whatever, there will be a bill. One thing that we're pushing very, very strongly on and getting a lot of support in both the House and the Senate on both sides of the aisle is expanding the above the line deduction to increase it from more than $300. And I would say that if I could ask one thing of this group, to the extent that you've got 2 great senators in Michigan, Stabenow and Peters, are both on board on this issue. But to the extent that you have some reach and some advocacy ability, let them know how important this is, because we've noticed and we've noticed throughout the country that without the charitable contribution deduction, we're losing contributions and amounts sort of at that mid-level. That, you know, the people that used to give $500 to the Federation now only give $250, or you know, they give $1,000, they give a little bit less, and anything that can expand that above the line deduction so that those individuals can see some tax benefit from their deduction, not only to the Federation, but to every charity, is very, very important. So the extent that you have some contacts with your senators, please thank them and ask them to continue pushing for this. And we're very optimistic that there will be something in these, although there's nothing in either bill right now. Our champions in both houses are pushing very strongly to get this $300 up to a much higher level, perhaps as much as $1,000, and that would go a long way, I think, to increasing deductions at that mid-level, if you will, for all charities, including federations. So I do want to make that point. And as far as retirement provisions, both these bills make the CRD and loan rules even simpler and take away some of the qualifications, so a lot more people could be able to tap into their retirement accounts. So those points, I think, will be there in some sort of final bill that we think will be done sometime this month. So I did want to make that advocacy point before we wrap up today. So thank you.
Steve, you often
There
send
was one more,
Oh.
Aileen, there was one more comment on the
Yeah.
chat that
Yeah.
I think is an important one.
Okay.
This idea of returning your early IRA RMD, and obviously if you had tax withheld, you'd have to put that money in. So if you took out a $100,000 distribution and you withheld 20% tax, you'd have to put $100,000 back, but you wouldn't have the $20,000, but it would be toward your 2020 tax liability.
Right.
But
Good
from a
point.
cash flow standpoint, you'd have to come up with $20,000 from someplace else. So it's an important point.
Very, very good point. Good point. Yep.
Absolutely. I did have a private question about, I know, Steve, you often send out information for us to lobby on. So if we would love to have any information that you have specifically about what you've just discussed so that we can, on behalf of our foundation, send that out. So
I'd be happy to do it. We have an alert that we distributed late last week.
Oh, okay.
And I'll make sure that you get that again, because yeah, we're part of a coalition with other national charities. We're pushing a whole bunch of things like, you know, getting a second round of PPP loans. I don't know if you guys self-insure your unemployment benefits that you pay to your employees if you had to lay people off. That's another issue that's important to the nonprofit sector. But the above the line deduction is a very, very important issue, and something that we are at JFNA obviously very much in favor of doing. So we'll be happy to send that to you. And again, you guys are lucky, and I would say Senator Stabenow especially has been a leader in advocacy for nonprofits. She's also the sponsor of, and it's related to this conversation, something called the Legacy IRA bill, and that would expand the IRA charitable rollover to allow for charitable gift annuities, which right now are not allowed, and allow it at a lower age level for those. I believe it's age 65, not 7.5. So it's a great piece of legislation. She's a great champion for the nonprofit in the charitable sector. So you guys are especially lucky.
Great to know. Thank you. So we have hit our 1 o'clock time, and we want to respect everybody's time, especially those folks, our wonderful, wonderful speakers. We're so grateful. I was on many, many, many PPP calls, and I learned a lot from Steve, and I've learned a lot today from Paul and Alan as well. So thank you so much. We have recorded this presentation, and we'll make it available to those of you on the call as well as others. And so if there's any questions that you had that didn't get answered, please send them to me, and I'll make sure that our speakers get them. Maybe they can help answer those. And just and also when we send you the recording, we're going to encourage you to also let us know of other programs you're interested in seeing. So we hope we'll provide that feedback. And in the meantime, enjoy this beautiful, in Michigan, beautiful, cool late summer day. And thank you all so much for having participated.
Thanks so much for inviting us.
And thank you to our speakers.
Thank
You're
you.
welcome.
Thanks again. Bye-bye.
I just want to thank the staff who's done a great job behind the scenes too. Done a wonderful job of keeping everything going and helping us organize. So thank you so much to our staff and our foundation committee. Thanks, guys.